開咗會先啦。
Yes, let's give a start. Okay, we have a quorum, and this is the appointed time. So thank you for attending the meeting of the Bills Committee on Insurance Companies Amendment Bill 2014. This is the 6th meeting. Thank you. Let's invite the administration in. Now, from the administration, today we have Mr. Eddie Zhang, Deputy Secretary for Financial Services and the Treasury, and Ms. Joanne Hong, Principal Assistant Secretary for Financial Services and the Treasury, and Ms. Annie Choi, Commissioner of Insurance. From the Department of Justice, we have Ms. Emma Wong, Senior Government Counsel, and Mr. Peter Zi, Senior Government Counsel. Welcome. Let's move on to the first item of the agenda. At the last meeting, the government or the Bills Committee completed discussion on the policy matters in relation to the licensing regime for insurance intermediaries. We'll move on to monitoring and disciplinary action for insurance intermediaries. The relevant paper is Electrical CB bracket 12027/1314 bracket 02. Would the administration please walk us through the paper, and then members can have the opportunity to ask the administration questions. Thank you. We're going to put forward an amendment to include Part 11, which is the new section in relation to monitoring and disciplinary action for insurance intermediaries. At present, they are self-regulated under the mechanism, and we are going to have a new licensing regime for insurance intermediaries. Last time we talked about the licensing regime, and this time we talk about regulation of insurance intermediaries and disciplinary actions in the new Part 11. Now, as mentioned before, we're going to set out some guidelines or codes of conduct that intermediaries are required to follow. This will be part of the legislation. Then I will invite members to read Para 6 of the paper. We attach importance to the conduct of insurance intermediaries because very often insurers sell insurance policies to policyholders through insurance intermediaries. So it all depends on the experience and the service provided by the insurance intermediaries. And apart from Hong Kong, in other jurisdictions, there are certain conduct requirements in relation to insurance intermediaries. Over the past 3 years, the OCI, the Office of the Commissioner of Insurance, and the 3 self-regulated offices received 1,400 complaints, of which 70% were against insurance intermediaries. Para 7 sets out that in new Section 89, there are broad principles of conduct requirements which a licensed insurance intermediary is required to observe. Now, broadly speaking, these principles are as follows. The intermediary should act honestly, fairly, in the best interest of the policyholder concerned or the potential policyholder concerned, and with integrity. And B, must exercise a level of care, skill, and diligence that may reasonably be expected of a prudent person, and the intermediary may advise only on matters for which the intermediary is competent to advise. And on making key decisions, if in the view of the intermediary there is any conflict of interest, such should be disclosed to the potential policyholder. And when dealing with the policyholder's assets, the intermediary should deal with the assets promptly, and it should be properly accounted for. And this will be done by the insurance broker, and these requirements will be set out in the ordinance in relation to conduct requirements to be observed by the insurance intermediaries. And the IIA will have to make rules setting out details of the conduct requirements that they have to observe. And at present, in fact, for the SROs, they already have similar conduct requirements. The codes of conduct does not have any binding effect. It serves only as guidelines for the industry and the practitioners to follow. Breaching the code will not attract any criminal liability. Instead, a civil action in the form of disciplinary action will be carried out, and it's set out in para 10 of the paper. Now, if the authority reasonably suspects the intermediary of any misconduct behavior, disciplinary action can be taken. And there is also the term fit and proper person. And in the last paper, we mentioned the criteria for an intermediary to be fit and proper. And these include financial record of the person, whether the person has any record of dishonesty, etc. Now, if the intermediary commits professional misconduct, or if the authority reasonably suspects the insurance intermediary of so, then an investigation can be launched. And subject to the findings of the investigation, disciplinary process can be initiated. Now, the IIA will set aside another group of staff to carry out the disciplinary process. And this team is completely different from the investigation team. And in para 14 of the paper, we set out the disciplinary sanctions. The most the heaviest penalty will be to revoke the license of the insurance intermediary. And the license can also be suspended, or the regulated person could be prohibited from applying to be licensed for a specified period. And the offender can be reprimanded publicly or privately. And a financial penalty can also be imposed, not exceeding $10 million or 3 times the amount of the profit gained or loss avoided by the person as a result of the misconduct. Before imposing the pecuniary penalty, the authority must first issue a set of guidelines to stipulate clearly the relevant provisions before the pecuniary penalty can be imposed. And in para 17, it sets out that the regulated person should be given a reasonable opportunity of being heard. Otherwise, the IIA cannot impose any disciplinary sanction. And the result of the disciplinary action should be set out in writing, giving the grounds of granting such disciplinary sanctions. And as mentioned just now, the IIA will issue guidelines to provide the insurance intermediaries with guidance, and this will also serve as evidence or carry evidential value, because if the disciplinary process and the decision is appealed against, there will be a tribunal dealing with the appeal case, and the case can also be further appealed against at the Court of Appeal, and by then the guidelines issued by the IAA will carry evidential value. That is the legal conduct requirements that intermediaries are required to observe. Now, on the guidelines in relation to the pecuniary penalty, it should set out the factors that should be taken into account when determining the quantum of a pecuniary penalty, as in para 19. They include the nature, seriousness, and impact of the contravention, the conduct of the regulated person concerned after the contravention, for example, whether it has taken any remedial steps or attempted to conceal, and thirdly, previous disciplinary record and compliance history of the regulated person concerned. And any previous disciplinary record would also be taken into account. And the pecuniary penalty should not have the likely effect of putting the regulated person concerned in financial jeopardy. For example, if the insurance intermediary is just working on self-employed basis or an individual basis, a hefty penalty should not be imposed. And the OCI currently has the power to impose pecuniary penalty, and they have also issued a guideline on exercising power to impose the pecuniary penalty, and it is attached at Annex C, and we will draw reference from this set of guidelines. We'll also consider the point about consistency. Well, the IIA will be expected to disclose to the public details of the disciplinary decision. This is also in line with international practices. There must be transparency for the public to know that for similar facts, for similar degree of severity, there should be consistency in terms of penalty, and there should be transparency so that the public can monitor the IIA. And there is also an independent appellate channel. It is a quasi-judicial body chaired by a former High Court judge or a person who is eligible for appointment as a High Court judge. And in hearing an appeal case, the judge will work with 2 market practitioners. A tribunal will be formed to hear the appeal case from both parties. And the IAT, the Insurance Appeals Tribunal, may vary the IIA's decisions or ask the authority to review its decisions. At the next meeting, we will discuss the details of the IAT and the appellate mechanism and the powers of the IAT. And there will also be a process review panel, our PRP. In fact, for SFC, the MPFA, etc., they also have independent process review panels comprising industry practitioners and professionals to review the internal procedures and operational decisions to ensure that the powers are exercised in a fair and consistent manner. Advice can also be given to the relevant bodies. So we propose to set up a similar PRP for the IIA. Now, that's the end of my introduction, and I welcome questions from members. Now, we don't have many members who wish to ask questions, so for the time being, I won't impose any speaking time limit. But do exercise some self-restraint. First, Mr. Chen Qianpo. Thank you, Chairman. Shouldn't we talk about the other paper in relation to the administration's response to the points raised last time before we continue to discuss this paper? Well, that should be agenda item number 2. I think, following the agenda's order, we should discuss the first item. That is regulation of insurance intermediaries and disciplinary actions. All right, Chairman. So let me confirm this. (64J, 64K) under 71 Well, if we are to discuss the amendment under Part 10, I think this is in paper bracket 03. And the administration, well, in the list of outstanding items, we have a number of papers. For example, 1637/1314 bracket 01 bracket 02, etc., and also 186 and 1817/1314 bracket 05, etc. So please deal with the first item on the agenda. So we're confined to discuss only Part 11. Yes, to facilitate the conduct of the meeting. Well, there are just too many. Well, anyway, Chairman, I'll follow your order. This paper is CB bracket 1, for the 2027 bracket 02 in para 7, in the best interest. Well, we understand that this is a very controversial issue.
The administration is now saying that the best interest concept is already applied when there is a change of policy. But if you are proposing amendments to so many disciplinary, provisions, in the past, people have a concept of the best interest of clients. But if in case where you have agents representing the insurance company, how would they determine what is the best interest? Because they would have signed a contract. An extreme example would be whether or not best interest means that you don't charge a commission at all. We all know, of course, that's not possible. So this is using an extreme example to explain that this issue may actually arise. I understand that you'll be looking into this, and we will continue to follow up on this one with you. The issues arising from that is really a cause of concern for many. I have many questions, Chairman. I'll leave it to your decision. If you want me to pause at a particular point and give the other members their turn to speak, I'll be fine with that. I think you can raise all the questions you wish to raise, and I can note them down. If the government cannot answer all the questions, then they can, they don't have time, then they can answer your questions in the second round. Well, okay then, Chairman, my first question is about best interest. I think this is one of the issues with which the trade is debating with the administration. Secondly, the appeal procedure and how we can further perfect that. And also in paragraph 8 of the paper, the new section 92 states that they also refer to Annex A. And the trade is worried about whether or not they need to make disclosures in respect of commissions. In F, under Annex A, the licensed intermediaries have to take necessary steps when they will need to disclose to the customers about any commission that they make. I think this is about investment-related products. Regarding disclosure of commission, I think we have many meetings with the IIA. The IIA had done a lot of work on this already. At a meeting comprised where more than 1,000 attended, the administration said that other than investment-related policies, they have no intention to extend that to life insurance. And this is what the government says in its paper. I hope the government can also spell this out more clearly and tell us what is its position. We all know that why the investment-linked products, there is a background to why there is a requirement for disclosure. But what about the commissions for intermediaries, or agents rather? And the government has indicated that it will not deal with this issue. If that is the approach, why is it that car salesmen don't have to disclose the commissions that they make? Does it mean that for any commercial act a person engages in, he will need to make disclosure? I want the government to ensure that this requirement will not be extended to other non-investment related products. The current amendment will make it convenient for you to simply require that investment-linked products should require that disclosure. Code of conduct will be accepted by the court as evidence, and the court will need to consider any compliance or non-compliance of the code. It also says that if the licensed intermediaries have failed to comply with the code, this in itself would not result in the intermediary being prosecuted in any legal proceedings. I understand that you will be issuing codes and guidelines, and I hope that the administration can explain this clearly so that members of the industry can rest assured. Could the government also tell us, explain a bit more about Section 9? That is, what do you mean by the intermediaries? Even if they fail to comply with the code, there will not be any legal proceedings. On the other hand, does compliance with the code means that there are no problems at all? And Section 12, definition of improper behavior. In 12D, could you explain that? That is, and according to the IAA, that is contravention of a provision of the amended ICO, contravention of a term and condition of a license granted under the amended ICO. I'd like you to explain what do you mean by hurting the interests of customers. I have my concern here because in the next paragraph, in D, you say that if any act or omission is likely to be prejudicial to the interests of policyholders, or I think here you're talking about the relationship with the code. Does it mean the full compliance with the code would mean that it will be all right, and any violation of that would that be a criminal offense? Perhaps I pause here because I still have many more questions. Chairman, I think the concept of regulation is not that we want to create some traps so that people could be caught. The regulatory system at the moment has been set up with the purpose of ensuring that the licensed person will voluntarily comply with the codes. For any agents or any intermediaries, we will require such organization to appoint a responsible person who would be responsible for promoting self-compliance. Of course, we will need to also provide some guidelines for the industry regarding best interests. We must know that insurance involves a very complicated contract. In the regulation of insurance and also in the regulation of financial matters, we need to deal with the question of information asymmetry. That is, insurance companies and the insurance intermediaries, they must have a better understanding of the terms of the policy than the average consumer. So we must therefore protect the citizen. Otherwise, people will lose the confidence in the insurance industry. And this is not something that was invented in Hong Kong. Internationally, there is a IAIS, International Assurance Regulatory Association, which clearly, has explained why we need such codes. That is, the consumers and the policyholders must have confidence in the insurance industry. I understand that some insurance companies are already adopting, customer-focused corporate culture, and I believe this is going to be the mainstream culture. So what we are proposing now actually reflects the regulatory requirements for the insurance industry, and such requirements are very common internationally. Mr. Chen already pointed out that there is already this requirement under the self-regulatory regime. For insurance intermediaries, before they become intermediaries, they will need to attend some examinations, and the examination clearly would refer to the different roles by the insurance agents and the insurance intermediaries. Now, I also like to draw members' attention to the syllabus for insurance practitioners. Under Part 7, Paragraph 2, even for an insurance agent, if he were appointed by the insurance company, he should still, hold his customers the highest level of integrity, and that he must, abide by certain regulatory requirements. Of course, some people say, well, no, we are now proposing a higher threshold. Now, we must say that, according to the bill, any breach of the code may not result in a criminal liability. I must say that once again, there won't be any criminal liability. There will only be a disciplinary process. All these requirements in the code of conduct would have to be, general principles. When it comes to implementation, we have to give the trade a clear guideline, and that is why we require that the IIA will issue such guidelines in the future. Members also asked a question about the guidelines. We stipulate clearly, that when any rules are being promulgated, the regulator must consult the public. So there must be a process to consult the public before you impose such a requirement, because these regulations are subsidiary legislations. Mr. Chen also referred to the annex, namely the part about disclosure of commission. So actually this gives the regulator a lot of discretion to produce subsidiary legislation relating to the regulation of insurance intermediaries, and that must be put to the public for consultation. We've also provided some examples to show that there are already some regulatory requirements under the voluntary regulatory regime. Mr. Chen referred to investment-linked insurance products, and there are already guidelines for those products. That is one example, but it doesn't mean that for the entire we have any requirement for disclosure for all for commission for all types of insurance products. We do not have that intention at the moment. We have made this requirement now because for investment-linked insurance products, we believe that we need to further enhance protect the policyholders. Members also ask about the effectiveness of the guidelines. Guidelines and subsidiary legislations are not the same. Guidelines are not legally binding, is not the law. Compliance with the guidelines or otherwise will not result in any legal liability. But I said earlier that in future, when an appeal has to be lodged to the court in respect of the conduct of an intermediary, the court will make reference of the code as evidence, meaning that a licensed person may feel that the IIA is wrong in imposing a fine on him, because in doing what he had done, he had fully complied with the guidelines of the IIA, and therefore he would use the guideline as evidence, saying that the IIA has required me to do ABCD3 and he has fully complied already. So the guideline will serve as evidence in court. Internationally, this is a very common practice, and I don't think Hong Kong is any different from other jurisdictions. I believe I've already answered Mr. Chen's questions, but I'll be happy to answer any follow-up questions. Mr. Chingimo, perhaps you can wait for the second round to ask your follow-up questions. if they have no intention to enforce the requirement regarding disclosure of commission. Yeah. Well, Mr. Sin Chung Kai.
關於嗰個文件最後尾嗰段裏邊咧，講嗰個覆檢委員會咧。
Now, a number of questions about the process review panel. I'd like to know more. Can you explain? Is it one of the panels under IIA, and what about this the appointment of panel members? Will they process individual cases, or what is its major function? Because it's not clearly spelled out here. Will it be able to make any decision, or does it just advise the IIA? And on the issue of power, well, the administration said that it has no intention of extending the scope. Now, but in future, once the legislation is passed, the IIA will be empowered to do so. At this stage, that is the administration's policy. Well, once the legislation is passed, but well, of course, consultation may also be necessary. But at least the IIA will be empowered to do so. For the process review panel, this is a panel comprising members appointed by the government. It's not a panel set up under the IIA, so it's not a subsidiary working under the IIA. Rather, it is an independent panel. Now, at present, for SFC and the MPFA, they also have the relevant independent panels. Now, take MPFA for as an example. A retired accountant chairs this panel with participation by members of the profession. The panel looks at the MPFA's conduct, whether it has exercised its powers in a fair and consistent manner, whether there is any undue delay in processing cases, and therefore the panel doesn't review individual cases. This is the function of the Insurance Appeals Tribunal, which looks at, the panel looks at the operational decisions of the IIA. At previous meetings, we did serve reports of the process review panels of the MPFA, the SFC and the Financial Reporting Council for members' reference. Well, perhaps I'll defer to the Commissioner to elaborate this point. Now, on the disclosure of Commission, I think we have different views in relation to investment-linked policies. Starting from last year, we have gradually imposed requirements on disclosure of Commission. But we also understand that insurance policies are not simple instruments, whether it's investment or non-investment link. There are also insurance policies that may be similar to other investment products. Because of the diversity of insurance products, it may not be feasible to apply just one standard. So across the world, there are different requirements. In some jurisdictions, there is no requirement on Commission disclosure. Some jurisdictions may impose a cap, so on and so forth. So I think depending on the line of business, we can then consider whether to require any disclosure of Commission. For investment-linked policies, since it is an investment in nature, we propose that the Commission be required to be disclosed, and this will be implemented in the coming 2 months. As for other products or policies, as I told the industry, the administration has no intention of extending the scope, because as I explained, this the insurance industry is rather complex. It's difficult to impose a single yardstick for all products, and we do not want to affect the industry. According to some jurisdictions in experience, the amount taken out in terms of policies actually decrease as a result of the requirement. So we will wait for the IA to be set up first before this will be further considered. As to whether the IIA is empowered to implement this in future, yes, it is or it will be empowered. Well, the difference is just that it's clearly spelled out in the legislation. But at present, because of complexity of the industry, we're not intended to implement this. I have one question about the best interest, Chairman. I heard from the industry that the issue about the best interest is tricky. Are there any alternatives for the industry? I believe in English is in the best interest. So, have you considered any alternative? Well, of course, I reckon you must have considered the other alternatives before you decide to use in the best interest. But can you give us the alternatives that you have considered? Chairman, as I said just now, the requirement that one should act in the best interest is not our invention. There are similar requirements in other jurisdictions. Let me give you an example. In Australia, in the Corporations Act 2001, there is such a requirement. There is a sorry, Deputy Secretary, please allow me to interject. Yes, I know you're going to quote the regulations from across the world. I'm not saying that this is not the practice. I know that you work on a basis. My question is whether the industry has proposed alternatives which you considered and ultimately rejected, and what are the reasons for rejecting these alternatives. Now, very briefly, the industry proposed once to scrap it and only to put it in the code of conduct or the guidelines instead of the primary legislation. And the industry also proposed the term fair interest to replace the phrase in the best interest. We do not accept these suggestions because, as I explained just now, in the best interest is the prevailing international practice, and in relation to the conduct requirements on the license, insurance, intermediaries, even the code of conduct. At present, carry this best interest element, and this has been implemented since 2 years ago, and we have 32,000 intermediaries at the moment, and 76% of them are insurance intermediaries. So I find it questionable if they say they're not familiar with the concept, because there are such existing requirements. Let me supplement. In their response to our consultation, well, of course, the major opinion is to scrap it, and there are also suggestions that clearer guidelines should be provided. And as mentioned by Mr. Chen Kin-po just now, insurance agents would find this worrisome, and I understand why, because they are concerned about their appointment, and they also have the they also need to safeguard the insurer's interests, and there is also a question on whether there will be a conflict. Now, in future, in the IIA's guidelines, it can be clearly stipulated the circumstances under which they will have fulfilled their responsibilities, as to whether no commission should be charged or whether there will be any conflict of interest. Now, in stipulating the best interest, we're talking about the framework of appointing insurance agents. As they work within this framework and sell insurance policies, they should act in the best interest of the policyholder. Let's say if the insurance company has 10 insurance products, the intermediary should consider within these 10 products what are the best interests of the policyholder. So their concern may be, what if there are other insurance products from other companies, and therefore it may not be the best interest of the policyholder to buy from us. And in fact, as for this point, I think the IIA can spell it out very clearly in its guidelines. How the agent can meet the requirements. But the major principle is to act in the best interest of the policyholder. And this should be spelled out clearly in the ordinance. As for the details, I think the IIA's guidelines can carry these details. All right, Mr. Chankin-Paul, the second round. So nobody else in the first round? Okay. I'll just follow up on the Commissioner's answer. Now, back to the point about the best interest. Now, on the one hand, we say that the insurance industry is complex and it's unfair to simplify or resolve conflicts of interest in a very simplistic manner. I'm happy to hear that Commissioner, first of all, understands as well the complexity and the possible conflicts, which could be numerous. Well, because for ordinary brokers, they represent a number of intermediaries, so there isn't any controversy that he should act in the best interest of the policyholder. Now, the problem is this element of the best interest is backed by legislation, and it may have far-reaching implications. Now, if an agent signs a contract, it should bear in mind the best interest of his principal, and how to strike a balance if he should also act in the best interest of his client. Now, let's say if the broker works for 4 insurers, of course the agent should get the best protection for his client among the 4. And what about the products outside the 4 insurers? Well, the point is the operation of the industry is far more complex than any outsiders can imagine. You can have all the talk. You can say that this is the practice across the world, but this is irresponsible. Instead, a commissioner understands our situation, and she has really poured her heart into it. So, first of all, yes, the industry's voice should be heard and the matter should be clarified by way of guidelines. Well, of course, it's best to do away with this phrase, but we understand the controversies, so at least it should be set out in the guidelines for practitioners to understand what or whether or not they have acted in the best interest. So my question is, when will the guidelines be ready? We're not going to threaten you to canvass your support. I will do it legally. As I understand that you have begun the discussion, and because in future, even after the legislation is passed, I hope the administration can keep an open mind on this point. Yes. Well, let me first of all supplement. In fact, in the bill, we have this provision. We understand very clearly the difference between an intermediary and a broker or an agent. Now, as an agent works in the best interest of his client, the insurer should not, on this ground, void the contract between the insurer and the insurance agents. So we already have a provision protecting insurance agents. As for the guidelines, as I said just now, in other jurisdictions, there are guidelines setting out in detail their requirements. The FSTB in January this year set up a working group on transition with participation by industry practitioners, and in February we started discussing with the industry on what should be included in this element of best interest in the guidelines, and examples of acting in the best interest and not in the best interest. And the FSTB also draws reference from other jurisdictions and give examples to the industry, and we hope to work with the industry in preparing the guidelines. I am not the IIA, so I cannot issue guidelines on behalf of the IIA to be set up, but our work will be very useful. It will serve as reference for the IIA so that it can work on a basis.
Chairman, if I may also supplement, we expect that the IIA in future, after it has been set up, as we find in paragraph 9, will publish codes of conduct for the agents. After the codes have been drafted, all the preparatory work mentioned by the Deputy Secretary, after drafting is completed, of course, we must consult the industry. At that time, I'm sure there will be a lot of room for discussion as to whether or not the codes are detailed enough and exhausted enough, and whether or not the issues of concern for the insurance agents have already been covered, or would there be other issues which have not yet been included. And if so, then the members of the industry can raise the opinion, and then the IIA will only finalize the code after they've taken on board all the views expressed by the industry. The first response of the Deputy Secretary is that the best interest of consumers, if it should conflict with the employee's contract, then the contract with the employer would be void. I'm sure your guideline will be able to deal with this anomaly. So I've already expressed the opinion of the trade. Chairman, if you may allow me to ask another question in respect of Section 72, Section 68, and there is one point here. That is, in future, if the client knows very well that the agent doesn't have the authority and he still did discuss the insurance contract with him, then the company would need to be responsible. Now, before we have the new legislation, we don't have such a problem. If the person who signs the contract knows that the agent doesn't have the authority to do that, and he still signs that contract, then the contract is not binding on the insurance company. Could the administration, also tell us what is his position so that I can relate that to the members of the industry? We're talking about Section 60A, bracket 3, bracket 4, and bracket 4B. If you're not ready to give us an answer to today, you can let me know afterwards, so that even if it goes beyond the authority of the agent, the insurance company would need to be responsible. They're worried that if the customer knows very well that the agent doesn't have the authority, he will still, approach the agent and sign a contract with him. If you can't give us an answer today, you can reply to my questions in writing later on. And now I'd like to go to section 14, disciplinary process. Again, this is very controversial. I think the debate is about a maximum fine of $10 million and 3 times the profits that has been made. I think I've attended many meetings with individual stakeholders and also, and I've told them that the government has no intention to cause them to suffer any losses. Actually, I've also gave briefings on your guidelines in respect of fines, and members of the industry basically knows the principle, namely that the fine will not be imposed at a maximum of 10 million, but they want to ask whether or not, let's say if the large company causes a major loss for a customer, then $10 million would be appropriate. For an ordinary insurance broker, then I don't think he can cause a customer to lose $10 million. So would you be prepared to consider a ceiling for the company and also for the individual practitioner? I understand that this is difficult, but could you tell us what is your position and whether you can consider providing smaller tiers of fines for so that the intermediaries can have the confidence. Let me answer the question about fines. We're well aware of the views of the industry. We have to, well, Mr. Chen already explained that for insurance intermediaries, you're talking about a wide spectrum. We have individual agents, and we also have multinational insurance agents or companies, which could be even larger than that of an insurance company. So when determining the fines, we have taken on board the fact that the intermediary could span a very wide spectrum. In the law, we have stipulated that fines for an individual must be lower than that for the corporation, and if that's the case, we think there is a problem there. We need to also regulate the responsible authorized person. If an individual, breaches, the rules, does that mean that he will have to, show the, pay a large fine? But sometimes the company may be very small, so the misconduct by a single individual. Of course, how much fine should be imposed, we have to consider the gravity of the offense. But the misconduct by an individual, certainly, if it was less serious than that of a company. But in the law, we have a problem. If we need to issue fines, we have to publish guidelines. And in those guidelines, can we provide for the differentiation? I'm sure we can discuss that with the trade later on. I don't quite understand Mr. Chen's first question. According to the existing insurance ordinance, perhaps I can provide a written response to Mr. Chen Kim-pao's question. Right now, the insurance company's ordinance already has, such a requirement. And Mr. Chen is asking about whether there's any discrepancy between those requirements and the requirements as proposed in the bill. Mr. Chen Kim-pao, I think you've asked too many questions covering a very large scope, and it's also highly technical in nature. Perhaps you can put your questions in writing to the Bureau so that they can give you a better organized answer. Mr. Sin Chung Kai. Chairman, I'm asking a similar question. For $10 million or 3 times the amount of the profit gained or loss avoided by the person as a result of the misconduct. If the profit is 3 million, 3 times of that would be 12 million, while the maximum is only, would the maximum then be 10 million or 12 million? The law stipulates that we can only impose a fine up to the maximum ceiling, 10 million. So if there's a deal which involves if the profit is 200 million, yeah, then the fine would not be 600 million. In setting the determining fine, of course, we have to consider a variety of factors. What is the rationale for setting the ceiling at 10 million? You say 3 times is the maximum. Now, if you have a case where the profit involved is only 2 million, then the guilty party could be fined a maximum of 9 million. Well, Chairman, in some cases, certain misconduct may not result in any gain or loss avoided. In that case, this would apply. But in sometimes, the guilty party deliberately mislead the client so that many policyholders would suffer and make an unreasonable profit. Then the fine would be 3 times of the profit or loss avoided. So you may not. So in other words, you may not be able to quantify the actual benefit or loss avoided. Chairman, if certain conduct is not related to obtaining unreasonable interest, then we'll invoke the $10 million fine maximum. Of course, we have to do this clause by clause, but I still need to ask this question. For the affected party, now after the appeal board has made a ruling, could the aggrieved person still take his case to the court? If I think the appellant can still take his case to the Court of Appeal. Well, I don't quite understand this part of the law. Clause 707 said orders of the tribunal may be rescinded by the Court of First Instance. Are we talking about the Court of Appeal or the Court of First Instance? It is the Court of Appeal. For the appeal tribunal, we will prepare a detailed paper for members to discuss as well. All right? We don't have anyone else in the queue. If you have any further questions, you may carry on. Mr. Chengenball, you would require written responses to the questions you asked earlier. In that case, we can let Mr. Sin to carry on. Mr. Raymond Wong has just joined us. Yeah, yes, I was attending a meeting next door. So which paper are we looking at now, Chairman? We are, well, Chairman, at the we haven't yet discussed the regulation of insurance intermediaries, and we're talking about 2027-02. Well, this question has been asked already. Please let me know, and I'll simplify my question. In paragraph 4 of the paper, it said we propose to set out the broad principles of conduct requirements for licensed insurance intermediaries in the amended ICO. If necessary, further details will be prescribed in subsidiary legislation to be made by the IIA after public consultation. In respect of this paragraph, my view is that there are many people in the insurance industry, and the mode of operation of the intermediaries may change from time to time. I understand that a specific legislation should be prescribed after due consultation with the trade to define the codes of conduct which the intermediaries must comply with. Would the administration consider, say, once every 2 years to review the code? And if possible, and if it is not prejudicial to the industry, would you consider conducting such a review, say, once every 2 years? And secondly, I'd like to refer to paragraph 7. One of the principles here is that he should exercise his best endeavor to ensure that there is no conflict of interest between the intermediaries and that of the customers. In paper 03, in explaining the best endeavor, you have added reasonable behavior. I'd like you to explain to us what is meant by make the best endeavor. Whenever I see, terms like that, I really find it very, very unacceptable. What exactly do you mean by the best endeavor? What would not be the best endeavor? In order to make, for the convenience of your drafting, you would simply use these terms. And what do you mean by making the best endeavor? As part of the administration, of course, you have to do, make the best endeavor. So I'd like you to tell me whether or not you can provide some case laws where as how the best endeavor is interpreted. And also, what is most controversial about the bill is about 89(a). That is the insurance intermediary when conducting the regulated activities. A, he must act honestly, fairly, in the best interest of policyholders concerned or the potential policyholder concerned, and with integrity. After many rounds of discussion, and I'm sure Mr. Chen Kim-po would know this very well, you have still yet to reach an agreement with the industry as to what is meant by the best interest of policyholders. Of course, we understand that the purpose of the bill is to protect the interests of the policyholders. But as a draft bill, I don't think it's appropriate for you to use terms like, using its best endeavor. What do you mean by the best interests of the policyholders? I think this is subject to interpretation. We're talking about the enactment of a law here. So could the Permanent Secretary explain this again? Perhaps you have already done so. But in my opinion, I'm always upset whenever I see expressions like the best interest. And paragraph 8 make reference to the new section 92, and the that is provides that the IA may make rules requiring licensed insurance intermediaries to comply with practice and standards in relation to the conduct of the intermediaries in carrying out the regulated activities, including some specified areas. And the rules will be amended accordingly. I'd like to know what is the amended version. Have you marked down the questions? Okay. I'm sure that he does. Well, I think I have expressed myself fairly well, and and paragraph 14 refers to the new section 84 bracket 4, which provides that the IA may impose the following disciplinary sections. What is of concern is bracket E and E1. That is imposing a fine not exceeding 10 million. The government's response is that applying different fines for the company and the individual may be difficult in terms of its implementation. Well, in that case, I think the $10 million fine, even though it is the maximum, may have the deterrent effect. But then this may also result in the intermediaries, to be worried.
And in the new section 84D, it says to reprimand a regulated person, public or privately. Well, according to the industry, to reprimand a regulated person in public would be too harsh. So would the government consider another option, that is to send a warning letter to the regulated person, not publicly? So that's all of my questions. Yes. Well, briefly, our reply is this. We agree that the industry's development is very rapid, so we just set out general principles. As for details, instead of setting them in the primary legislation, we'll set out in the subsidiary legislation so that the details can be amended to tie in with the industry's development. I can say that we don't need to wait for 2 years. We can have a review in less than 2 years. So I agree with Mr. Wong that we can change it subject to the industry's development. As for the best endeavor, we've considered the actual operation of the industry. There are examples in which prima facie something have been completed. For example, a form is given to a potential policyholder to put ticks in, so it seems to have been complied with the requirements. But after putting the ticks in the form, the policyholder may not fully understand the policy, or it may not be most suitable for the policyholder. That's why in the legislation we include the element of the best endeavor. That is, the needs of the potential policyholder should be considered, and the law will be enforced in a reasonable manner. That's why we have included this explanation. As for the 10 million pecuniary penalty, I explained just now, and let me briefly explain just now. For intermediaries, we have individual intermediaries, we have small or we have company intermediaries ranging from a one-man company to a transnational company. So we say that an intermediary working on an individual basis should face a pecuniary penalty far less than the amount applicable to a company. It may not be in line with the principles of the legislation. Well, in the guidelines we can discuss with the industry. By then more details will be set out in relation to the pecuniary penalty. Hopefully this can clear the doubts raised by Mr. Wong. And for the remaining answer, I'll defer to the Commissioner. I'd like to respond to Mr. Wong's point. As for a separate tariff for the company and for individuals. Now, let me say something from my experience as Commissioner for the past few years. You cannot assume that for large intermediaries, insurance companies, the profit or loss involved may be greater. Even for intermediaries working on an individual basis, a misleading practice may be repeated, and some policies may also carry a large amount. So in terms of the complaints received, we do not distinguish between intermediaries working on an individual basis or as a company. So the separate tariff may not reflect the true situation that we have. As a result, we can only set a maximum amount. However, based on the facts of the case, based on the breach, regardless of the intermediary being a person or a company, we consider whether the intermediary is a first offender, whether any remedial action has been taken. We consider these factual factors instead. So in the guidelines to imposing pecuniary penalty, these details will be set out as mentioned by the Deputy Secretary. So we should not impose a higher tariff for companies and a lower one for individuals. Now, about the other point raised by Mr. Wong in terms of the best interest, there is a suitability test for intermediaries. That is, whether the policy is really suitable for the policyholder given his her or her personal and financial circumstances and also other actual circumstances. We agree that these details should be set out in the guidelines for the industry to follow. And as mentioned just now, in February, the administration began discussion with the industry through the working group on transition. We hope to achieve some progress by this working group. Mr. Kwok Wai Keung, first round for you. I'll go first, Chairman. I just came down. I was listening to the broadcast just now upstairs, and DS just now mentioned that they have continued to consult the industry on points like the $10 million in the best interest, etc., as early as 2 or 3 months ago. However, since April all through September, members have been meeting with deputations and industry practitioners as well, and it seems they still have strong views on these points. So it's not very consistent with what DS said. I'd like to know what level of consultation you made, and is it because the consultation was too broad in scope, such that individuals came to members instead? Well, I didn't say that all problems have been resolved. I just said that all along we have been discussing with the industry on the details of the guidelines in relation to the best interest, and the working group on transition under the IIA have minutes which are available online. It's also available online on the website of the ICO. The industry doesn't accept our proposal. They suggest that the best interest should be scrapped, and we do not accept their suggestion. We feel that details should be set out in the guidelines instead. As for pecuniary penalty, we do not agree with the industry's suggestion that there should be separate caps for individuals and companies. We've noted the concerns of the industry. I didn't say that all problems have been resolved through discussing with the industry. As for reasons why we do not accept some of the industry suggestions, we have explained clearly to them. Well, Chairman, from the perspective of the public, it is a good initiative to set up the IIA. The industry also feels the same. However, without forging a consensus, if the legislation is too rigid, the industry's concern is that they would not have any flexibility. Now, the industry is so vibrant because of the efforts made at all levels of the industry, and some of the suggestions have not been accepted by the administration. And also on the best interest, your explanation is that in other jurisdictions there is also the element of the best interest in their laws. However, our industry's position is very clear. It is impossible for them to get all the policies in the market. If you jump to the best interest, and if the intermediary doesn't have available to him the best, so-called the best policy for the policyholder, he may face prosecution. And how would you help the intermediary? And even after the IIA is set up, as mentioned just now, there will be discussion on details of the guidelines. So at this stage, perhaps we can leave room for more details to be set up later when the IIA is set up in future, after going through consultation with the industry. If you put in all the details and make the legislation rigid at this stage, how can the industry survive? Yes, Chairman, I'm happy to be enlightened as to what cannot be implemented. I'd like to follow up on the details. But I don't agree with Mr. Kwok Wai Keung. We're not putting in all the details and make everything rigid at the moment. We're just setting out the principles. As for details, they will be set out in the guidelines. So this is being flexible, as I explained. And we are also leaving room for any further amendments to tie in with the industry's development. This is the design of the ordinance. As for the principles, at the outset, as I said, we should deal with the issue of information asymmetry. And this is a point of regulation. And there must be regulation to protect the disadvantaged. And we should not turn a blind eye towards breaches. And as mentioned in Para 6, 70% of the complaints received in the past few years are about insurance intermediaries. I'm not saying that insurance intermediaries are doing a bad job at the moment, or that there are major loopholes in the regulatory regime. The point is, we need a new system, and we need suitable provisions to make the regulatory regime work. We're not talking about very harsh regulations. We are just following the lowest international requirements, not the highest ones. So if the industry is saying that there are provisions they cannot comply with, do tell us. Now, the point about the best interest have been discussed repeatedly. And let me reiterate that in the MPF ordinance, they have already set out the requirements, the regulatory requirements on the MPF intermediaries, and the legislation took effect in November 2012. And there are 32,000 intermediaries in the market. 76% of them are insurance intermediaries.
I don't know whether or not the MPA system has been challenged previously. In the MPF ordinance, how often would the best interests of individuals be involved? Because basically, there wouldn't be a case where the intermediary will take your business and then split it with the others. I think this is the decision of the principal. I think under the MPA ordinance, I think we should be defending the interests of the policyholders vis-a-vis those of the intermediaries. Today, you are now standing on the side of the industry practitioners. I think we need to be standing on both sides. As Chairman, I would like to remind you of that fact. Well, that is why, Chairman, we're talking about three parties here. But I don't think the FTU people should be schizophrenic. Of course, they have to defend those who have, the workers who have small amounts in the MPF accounts. I think we need to balance the interests of all sides in deliberating the bill, and we need to take on board the different views and perspectives. Actually, I've also considered this before, and I asked whether or not the industry has put forward any alternative proposals, and you've already answered my question. If you do not use the term best interest, I don't think we can replace it with secondary interests. Until a better alternative is put forward, only then will I consider it. And now I'd like to go back to paragraph 7C. You're now issuing licenses. Under 7C, in Chinese, say, may advise only on matters for which the intermediary is competent to advise. You're issuing a license here. After the person is issued a license, he should be competent to do that. Whether or not a person is competent is a matter of subjective judgment. You say if you license a person, you allow him to do things which are covered by the license. That would be a more objective criterion. I mean, sometimes a person who is licensed may not be competent, whereas there are others who are not licensed could be competent. So the question in law is whether or not the person has a license. I find this rather awkward, Chairman. Perhaps I could explain here. I think it is our licensing requirement that the license holder must have the competence. That is, under the current circumstances, he must have the necessary or requisite level of education and has also attained or passed the professional examinations covering different subjects in the insurance industry, including life insurance and so on. He would need to, pass these examinations before he could become an intermediary in the relevant field, and that is what we mean by competence. And talking about the conduct, after the person has only passed an examination for life insurance and he has not attended the examination on general insurance or other insurance products, and he sells an insurance product, he doesn't have the competence, then he would need to be punished. And Mr. Sin explained it very well just now. That is, even if you are an intermediary who has passed the examination for life insurance and you fully comply with the licensing conditions, but if the insurance company issues certain products, there would be internal training within the company, highlighting the salient points of the products and also advising the intermediaries which type of consumers would and whether it's suitable to a particular group of categories. So if you are not licensed to sell those products, then you are not competent. I begin to understand why you draft it in this manner, but I'm still confused. Well, is it the case that for certain types of licenses, the intermediary may not be competent in selling certain products, so that's why you use the word competent? But, Mr. C, why don't you formulate your question clearly first? Why didn't you organize your thoughts before you... Let's not waste any time. If you may let me ask my question instead, because why don't you structure your question before you put it to the Deputy Secretary? Does the IAA actively investigate, or will it only investigate upon complaints? According to the bill, when the IAA has reasonable doubts. So in other words, the IAA has the initiative, either upon complaints. So if there are reasonable suspicion, then the IA will also take the initiative to investigate. I think, Mr. Kimball, you need to pay attention to that. My second question is this. In paper 02, paragraph 14E, which is the proposal, that the maximum fine should be 10 million, and there is the argument that this is too harsh. I think there are two subparagraphs here. Bracket I is $10,000, and 2, 3 times the amount of the profit gain or loss avoided by the person as a result of the misconduct. If the $10 million were to be reduced, then for I think you can have a sort of cover provided by bracket 2. With bracket 1 and bracket 2, then I would have the discretion to invoke either bracket 1 or bracket 2. For large insurance companies, I can charge them pursuant to bracket 2. For the small players, then you can invoke bracket 1. And for bracket 1, should the maximum be set at 10 million? Since the trade or the industry has such strong views, could we consider amending that amount? Because when you need to enforce it, you can still fall back on bracket 2. You can even increase the multiple under bracket 2. It doesn't necessarily have to be 3 times. Where there is a misconduct resulting in the person concerned to suffer a loss of profit and so on, then you can, find remedy under bracket 2. Chairman, thank you for that suggestion. I may not necessarily agree that bracket 2 will cover those areas not covered by bracket 1. There is a causal relationship here. That is, when there is a misconduct, the intermediary makes a profit or successfully avoided a loss, and there is a misconduct here. I can give you an example. A large intermediary, insurance company which is an intermediary, has not done a good job in protecting the privacy of its customers, and as a result, systemic loss is caused. So it's internal failure on the part of the company, but it doesn't mean that the company has made a profit or avoided any loss. But such a misconduct may result in the privacy or confidential information of policyholders being jeopardized. If they were disclosed inappropriately, the impact could be very significant, and it's a very serious misconduct. We may need to impose a higher fine in this case. So it's not therefore the case that number 2 will cover those areas not covered by bracket 1. So you're saying that so the misconduct may have nothing to do with profit gain or loss avoided or loss on the part of the policyholder, but the gravity of the misconduct may be such that that it could be very serious, in which case you will invoke bracket 1. If you lower the multiple, then it will not have the deterrent effect. Let me give you one example, an exaggerated example. If you have an intermediary who disclose information of his policyholders as well as the information about the beneficiaries to improper persons, and let's say 10,000 policyholders are affected, would you agree that this is a very serious misconduct? In this case, if a fine had to be imposed, would you agree that we need to impose a higher level of fine? Good. And any further questions? Mr. Chen Kim-bo, followed by Mr. Sin Chung Kai. Chairman, the Deputy Secretary cited the example of the MPFA. I don't think that is an appropriate example. The MPF is a lot simpler, and the amount involved is a lot smaller. You cannot imagine a scenario where people complaining the MPF insurance agent, advising them to buy the wrong product. But for annuities and so on, the turnover every year is already 100 million. So the best ever and the best interest. These two expressions may result in legal liabilities which are not clearly defined. So please don't cite the example of the MPFA anymore, because the risk involved for MPF is a lot smaller. Some people saying that the individual travel scheme is progressing so slowly because the responsibility is too onerous and they're only getting a commission of $300. But on the other hand, many people are actively selling new policies amounting to $100 million. We're only talking about life insurance here, and not counting the renewal policies and so on. So you really have to stand in the shoes of those who are selling policies, and also the insurance companies, and find out what are the concerns. Don't cite any examples for which when there are actually no real problems. I also like to talk about the code of conduct. The trade thinks that this should be removed, but I still think that is one solution to come up with some guidelines so that people would not fall into traps. And I think this is the most constructive suggestion. I believe you'll do the same for the best endeavor. And secondly, I'd like to go back to Section 23 of the paper.
呢度咧就大家知啦。
Independent appellate channel. An aggrieved person can appeal to the Insurance Appeals Tribunal (IAT), but we're not talking about this stage because it will be too late when the case reaches the tribunal, and there will be cost implications. We hope that the administration, since it has a professional team, the administration is saying that they can decide whether or not to refer the case to the professional team, and that professional advice may be sought. Now, what we want to strive for is this. Should all these cases be referred to the professional group for expert advice, or the expert group? What if the advice is different from the decision made by the IIA? Then I'm not saying that the decision should be overturned. I'm just saying that you should make the best use of the expert group, since it comprises experienced professionals, and the experience of the experts in the expert group or in the disciplinary panel will not go to waste. If you appoint somebody inexperienced, somebody new, there may not be any consistency in passing penalty. I hope there won't be any waste of resources. I hope the administration can seek legal expert advice from the expert group. As for the process review panel, we understand that this is not for the purpose of reviewing any individual case, and Mr. Yu Si-wing cannot attend the meeting today. He has asked me to ask this question. That is to ask the administration to invite more industry practitioners to sit on this PRP. Yes. Let me first respond to the point about MPF being not as important as the insurance industry. Then I don't agree, Chairman. I'm talking about complexity, not importance. Well, in fact, in terms of regulation, it's much harsher, and we do have professionals from the sitting on the PRP. I must talk about the PRPs for the Financial Reporting Council or the MPFA, both panels comprise professional practitioners from the industry, and the independent PRP for the IIA will be the same in the future. Let me tell you something about the design. In imposing disciplinary sanctions, the decision will be made by the IIA, and there is an expert group under the IIA. And if the IIA is of the view that it doesn't have the expertise to deal with a particular case, the case can be referred to the expert group. And because we know that the insurance industry is very complex, and even a practitioner within the industry may not be familiar with all the products. For example, a maritime insurance policy may be very specific, and we may need to engage experts in this field. The point is, there should be a clear body responsible for making this decision. So the IIA can only seek advice from the group. Ultimately, the decision will be made by the IIA, and the law sets out very clearly that the IAT, the Insurance Appeals Tribunal, can review a disciplinary decision if appealed against. So procedurally, it's very clear that the decision is to be made by the IIA. And I want to clarify that in imposing a disciplinary sanction, the IIA can seek advice from experts. But we need to strike a balance. The decision made by the IIA should be made in a fair and impartial manner, and it should not be subject to any interference or undue interference. Mrs. Sin Chung Kai, on the best interest, I want to express my view again. I don't think it's appropriate to scrap this provision at this stage. Just now you explained about the alternatives, and Chairman, I'm not a practitioner in the industry. I may not be as familiar as those practitioners, but I understand that policyholders would need to take out policies from or through intermediaries, and the commission may be charged at different rates. So the best interest means that the policy is in the best interest of the policy holder, and that the policy is one of the policies available to the intermediaries. We should allow grounds of defense if the intermediary has to face disciplinary action. Now, I'd like to know, in terms of advice, does it mean in terms of licensing matters, or is it more appropriate to amend the wording, because the in granting license, scope will be defined. I don't know whether there would be a license for certain products. Let's say if there is a new product and it is included in the license, and if I'm not familiar with the product, will I face action? But it's included in the license, so wouldn't it be too vague? Commissioner, let me give you an example why it should be written this way. The license would stipulate what products the regulated persons may sell. That's subject to the examinations he has taken on non-life insurance products, things may be more complicated. As Mr. Chan Hin-po may understand, there could be insurance against fire, car insurance, airplanes, vessels, etc. That depends on the specialty of the intermediary, the companies he represents, the business dealings, or with which company he has business dealings with. So that depends on whether he is fit and proper for selling such products. Let's say if the intermediary normally sells life insurance, but is he expert? If a client wants to take out insurance policy for a vessel, we understand that those policies are very different from ordinary policies. They're much more complex, and in the license, well, we cannot include all the details. For example, we can only say that it can sell non-life insurance products. So I think it depends on the circumstances then to decide whether the person is a fit and proper person. Well, if you say that this person has undertaken some courses and or have worked under certain companies in that field, then things may be different. So the member is correct. If it's stipulated in the license that he is fit and proper for the certain scope for which exams have been taken, then yes, he can sell those products. But the details may not be all included in the license, and that will depend on the facts of the case. Does it mean that the categories in your license are not clear enough or meticulous enough? We have 5 major categories: companies, individual, broker, agent, and then in the license will stipulate the exams the agent has taken, for example, life insurance, and say if the person has not taken any exam regarding investment-linked products, then he can't sell such products. Now, insurance industry is very complex. There are different property-related insurance policies. So usually there are some major companies or intermediaries responsible for selling property-related insurance policies. If the person has never been engaged in the field or has never undertaken relevant courses, then this person may not be a fit and proper person, and the license may not reflect these details. So let's say somebody sells promotes products to B, and B eventually buys the product, then can civil action be taken if in the end it's revealed that A is not a fit and proper person? Of course, you can impose disciplinary sanction. Well, if civil, yeah, if you talk about the civil action, then the civil action can be taken out on any ground. But in terms of our licensing regime, in our investigation, we're talking about what is meant by a competent person. And we look at the 2 limbs as mentioned, but I also note your point. Maybe we can go back and think about it. Yes, please do. I'm talking about the practitioner. After I get the license, which stipulates clearly that I have the right to carry out these activities, even if done poorly. Now, things are clear. But if things are vague, then and I carried on some activities, and then the buyer eventually suffered loss as a result of my activities, and then I may face disciplinary action because of my incompetency, and then civil action may be taken out against me, and I may need to face huge risk. Well, Chairman, maybe we can go back and reconsider whether amendment is necessary to address Mr. Sin's concern. I understand his concern. In our bill, we should consider if the person doesn't have the relevant professional knowledge, such professional advice should not be given by this regulated person. These are basic requirements, and the industry is evolving, and there may be diverse products and new products being developed. So I'll go back and consider Mr. Sin's point. Mr. Paul Chair, well, to address Mr. Sin's concern, definitely the answer is yes. Apart from a breach of professional misconduct, or apart from committing professional misconduct, if erroneous advice is given due to negligence or due to any blatant breach, the person may be subject to civil claim. Well, as I heard, many issues were about the wording, whether the wording is too vague, whether things are not clear, and it's a question on how stringent the administration would like the regulatory regime to be. And for more traditional sectors like the legal sector, we are very familiar with these phrases like the best interests or the best endeavors. We have case laws in our common law system that clearly spell out what they mean. And in disciplinary hearings, regard will be given to these elements. I don't think your standard is unique in the insurance industry only. You also have regard for other standards in other industries. The question is how high you want to set your standard, comparing to other regulated industries at a comparable level, or would you think that for the insurance industry, perhaps things can be a bit more lax?
In question, perhaps we haven't come to that point yet. For disciplinary hearings, first of all, will the hearings be held in public, and will the person being complained against can choose the hearing to be held in public? And secondly, could legal representation be allowed? Chairman, when we discussed the code of conduct, I think our policy consideration here is that in the principal legislation will lay down the principles, and the principles are rather general in nature and that cannot be helped. I explained that we will be coming up with subsidiary legislation and guidelines to spell out the details, and they will enable the whole system to become more flexible and also compatible with the development of the industry, and then it can be updated from time to time. On the subject of appeal, certainly a legal representation will be allowed in the case of appeal. No, I was asking about the disciplinary hearing. Definitely. So this will be spelled out in the details. You haven't come to that stage yet. We will consider this further, and if need be, we can provide for that in the legislation. Is it the case that you haven't, thought about that at this stage, or have you never thought of it at all, or have you thought about it and came up with a different conclusion? You expect that there will be such, stipulation. All right, it's not there yet, but they plan to put it in. But there is a case law regarding a disciplinary hearing where the defendant was not allowed this legal representation and therefore was challenged by the judge. So I think it's a basic right for the person who is, charged in a disciplinary hearing to be entitled to legal representation. Now I still have some time. I don't want to miss this opportunity. I'd like to ask whether or not is it the case you haven't come to the stage to consider such details yet? That is, whether the hearing will be held in public and whether legal representation will be allowed. The simple answer is we haven't started to consider such details yet. Now that Mr. Chair has raised those points, please take note of those points and take care of them, going forward. So if they're not there already in the regulations, please consider putting them in. Mr. Chair, any further questions? I still don't understand, don't know what was your exact answer. How high do you want to pitch your standard? Would it pitch it to a level comparable to those applicable to doctors and lawyers and accountants? Or do you have a lower threshold? Chairman, in setting out the Code of Conduct requirements, we've made reference of the IAI's basic requirements. We've also made reference of the relevant requirements pertaining to regulation of the insurance industry in other jurisdictions. So your reference apparently have been limited to the insurance industry, and you've not considered the standard applicable to other industries, and also with the use of the terms like best interest and best endeavor. Yeah, basically, we've made reference of the regulations regarding the regulation of the insurance industry and the financial industries in putting forward our proposal. Mr. Shankinbo? Chairman, I'd like to go back to Section 71. I'd like to ask whether we've discussed 64K and J already. We have a paper which is follow-up to our last meeting. Actually, it's the previous paper, but I don't think we've discussed that yet, or are we going to cover that later on? Chairman, if I recall correctly, at the meeting on the 21st of July, we have already given a written response. I can also give a simple response now. So you're talking about Annex B. There we're talking about the existing insurance ordinance, which stipulates that the insurance companies and the insurance agent, companies with insurance companies cannot be confused as the same. That is for broker companies. A single individual cannot be the director of both companies. So the policy intent is that insurance agents should represent the insurance company, and an agent, even if it were a company, can only accept appointment by 4 insurance companies, and the agent will represent the customer to look for the best insurance solution in the market. If a person were allowed to become an insurance agent, an intermediary, an agent and a broker, then there might be a loophole there. We already have this restriction now. In the new ordinance, we've changed the wordings, for example, the wordings like licensee and so on, so we've made some corresponding amendments. But some people in the trade agrees with the proposed amendments in the draft bill, while there are others who find them problematic. So after meeting with the industry, I hope they will look at 64J and K more carefully, and we'll be happy to hear whether they have any further views. And if you want us to make further refinements, we'll be happy to do that as well. Well, after you have given us your written response, we can still have more discussion. I understand that the COI have also said that it's not that we don't allow you to acquire the company, but you cannot participate in the management of the company. For example, in participate in the discussion about the strategy of the company, so on. I'd like to know, under what circumstances will you clarify that? Only 2 days ago, we were still discussing this. I explained to them that there's some progress made already. So perhaps you can, Commissioner, if anytime if the trade industry would require another meeting for us to explain to them the intent for the bill, I'll be happy to do that. The Deputy Secretary already told members that we are not saying that we don't allow an agent to acquire another or the broker of one insurance agent to acquire another insurance agent. As a shareholder, you can do that. That is a normal business transaction. You can even become its director. The only restraint is that you cannot take part in the regulated activities for that other company, such as the sale of insurance policies. So you cannot participate in that. So the way the industry is structured is that we have a distinction between agent and broker, and there are two approaches applicable to them. If you participate in the regulation and at the same time you keep acquiring insurance, agents, and you take part in these activities, then the whole system of insurance agents will be defeated, because you would actually, everybody would become brokers and there won't be any agents anymore. And in fact, in the course of our daily work, and given that the law ordinance is not very clear at the moment, indeed we have such a scenario. So the Deputy Secretary has told members that some companies in the trade have expressed a concern, and that's why this time we want to spell this out clearly so that everybody would know what they can do and what they cannot do, and that so that in order there won't be any more gray areas. But it's not our intention that we don't allow them to make acquisitions or be the director of another agent, so long as you do not participate in its regulated activities. I think these are rather technical discussion, and I'll be happy to talk to the trade further. We've already had earlier discussions, but if anyone in the industry were interested, we can certainly have a further dialogue with them. Perhaps after the meeting, I can take this up with Mr. Chan and make the necessary arrangements. I think it's almost time for us to wrap up our meeting for today. For CB 2027-13-14-03 and CB1 1637-1314-02, and also CD 1817-13-14-05, CB 1227-13-14-05, and CB1 186-14-15-02 had already been circulated to members. And they are actually related to views expressed by the public after the bill has been proposed. I think our deliberations today have already covered those. Basically, it's all around these major issues, these major items. For example, definition of best interest, disclosure of the coverage of commission, the guidelines should be clear. And the power of the review committee, and the question of fines, and whether it's too draconian. So those are the issues. I suggest that members can go back and take a look at those again, and if there are any further questions, we can follow up on them at our next meeting. Date of our next meeting is I have tentatively scheduled for 2 days, the 24th of November, a Monday at 2:30, and the 9th of December, a Tuesday, again at 2:30. All right? I think the Secretariat will inform members in due course. All right, if there's no other business, we may now adjourn. Thank you.